Welcome to Guardians of Innovation, Patent and Trademark Law.
Welcome to Guardians of Innovation, Patent and Trademark Law with registered patent attorney Vincent LoTempio. I'm Evan Mack, and today I'm joined by a very special guest, Andrew Lees, founder of Stoke Ventures. Andrew specializes in helping entrepreneurs take product ideas from rough concept to market-ready reality. Today we're discussing something that trips up a lot of inventors: filing a patent before the product is ready. This is From Idea to Product, why the right sequence matters for innovation and protection. Welcome, gentlemen.
Thank you so much for having me.
Yeah, thanks for joining us today, Andrew. I really appreciate it.
Yeah, absolutely. Yeah, I'm really excited about it. I'm excited to talk about this, especially the topic that you just mentioned, Evan. So, and whatever else we can get into.
You guys are both joining us because there's a lot of information I think we all need to know. And I want to start with you, Vincent. When someone comes up with that great idea, that $1 million idea, what's the first legal step they should consider to protect it?
Well, our first step usually is a search. And then once we make a determination that it's patentable subject matter, then we actually we file the application. And then sometimes we use a provisional or non-provisional application. And the purpose of the provisional is let them go out there and have an opportunity to try to see if they can get something in the right momentum.
And Andrew, a lot of inventors come in with patent already filed, but what problems do you run into when that happens?
So, yeah, I've seen it where we've had a bunch of clients who've come to us. They already have. Sometimes they wait years until the patent is actually granted. And they kind of think that's the first thing I have to do, get it granted. Then they can develop it. Then they're sort of safe to develop it. And what we've run into a lot of times in those cases, not every time, but a lot of times, what happens is they didn't necessarily know how the product would be developed, what the details of the product would be, if it's even feasible, like if the functionality they envisioned is even feasible, or if it's manufacturable. So if it's not going to work the way they thought, and it's not going to be able, if we can't make it, then we have to change the design from what sometimes we have to change the design from what the patent is saying that it should be and what the patent is protecting. And then in that way, we're able to make a product that can be, that works properly, that people are more likely to engage with and more likely to buy. And then also, obviously, we have to be able to make it too. And so we don't want to, and if we do that, then we're designing outside of the boundary of the patent. So then it's not protected. But if we were to design it within the boundary of the patent, in some cases, then we have something that doesn't work or can't be made. So what we want to do is, and this is why I'm so excited to be talking to you today, Vincent, is because we always want to be working with the patent attorney, hand in hand, doing from start to finish, from the search through the development, the provisional or non-provisional, utility, design patents, everything, to make sure that whatever we're designing, you feel like that can be protected, or we figure out what can be protected, what can't be, and and then we ensure that the product is well protected, and that it also is the best version of the product for market that it can be.
And Vincent, how early is too early to file for that patent, and what are the risks of filing too late?
So too late is if it's out there in public and people have filed something over the top of you and you lost the race to the patent office. Remember, it's a race. The first person to file wins the race to the patent office. But Andrew just said, research and development takes time, and you'll find as you go through it how you thought it was going to work originally didn't work so well. And so if you write that patent up in a way that you first envisioned it and it really didn't work, and you never even make one like that, then really what good is it? One concept I think is important for inventors to understand is that a patent doesn't give you a right to make it. A patent gives you a right to stop others from making it. So if you get a patent on something that you're never going to make and nobody's ever going to make, it's really not protecting anything. So we really do have to work with somebody like Andrew to find out, is this really how close are you to the finished product? And can we describe it in a way that it covers the finished product, even if you're still in the middle of research and development? And yeah, Andrew, I guess that's a good question for you. I mean, how do we work hand in hand with the inventor and the patent attorney to make sure that we time it right?
Yeah. So the best thing I think is, you start with that search, like you talked about. Maybe you file a provisional patent, depending on how confident we are with the way that the development is going to go. And, if it's a relatively simple thing, sometimes you can, get started on that sooner than later, but you only have a year with that provisional patent. So we want to make the most out of that year, possible. So if we can delay that a little bit, of course, it's a little tricky, right? Because you said it's a race, and it is. We want to get the earliest protection, but we also want to make the most out of that year. So we're kind of balancing that a little bit. So as soon as we can file that provisional, the sooner the better. But what we want to do is take a look at the product, the concept, figure out. We brainstorm. We just did this for a product yesterday, actually. We had a big whiteboard, and we just went nuts trying to figure out anything that would be valuable to the product that we could file a claim for, because it was going to be a little bit difficult to file a claim to actually get a patent granted for what the inventor originally wanted to, was originally envisioning. So we're trying to think of anything that would be valuable, that not just so that we could get a patent for anything, but something that would actually be valuable to the patent. So I think seeing the product, working with you to figure out, like we make a big list of features, and what are the benefits and the features, and what are the things that could be really valuable, and we're also thinking about through the lens of how do we design it and manufacture it. And as long as we feel like those things are feasible, and we can work with you to figure out if those things are actually patentable, and then we can choose those features that we can actually protect. Of course, we're not going to be able to protect every feature, and that's okay. We can have features in the product that can't be protected, and that's okay. But yeah, I think just having that discussion back and forth to figure out what can we design and what can we make, and then also, does that align with what can be protected?
Well, how do you do that with like a working prototype versus an actual product that you're going to go to sell with, just to see just a proof of concept, I guess?
Yeah. So the way that we develop products is we're thinking about manufacturing from the beginning. So we don't design for prototyping. You can get into trouble for that because you can design something that works well with a prototype, and then you have to sort of, and some firms do this. They kind of design really quickly, and maybe it's very cheap or whatever, or cheaper. They design something quickly that can be prototyped to get this proof of concept thing, but then it has to be redesigned to manufacture, and things can change in that process. So that's the first thing, is we're always designing for manufacturability. Our prototypes are as close as possible to production. So when we're testing prototypes, we're pretty confident that, yeah, production is its own sort of development phase. There are things that we're going to have to figure out there, but we're confident that we're going to easily be able to figure those things out. And the prototype represents the production product very closely. So whatever we're learning there, we're confident that it's going to, translate to the final product. And if a feature doesn't work, or if it has to change or whatever, then we would communicate directly with you to figure out, okay, this thing doesn't work as well as we thought. We're going to have to change it so that it functions. The mechanism, let's say, that we thought was going to be able to do something, it doesn't work the way that we thought. And maybe the mechanism was going to be a unique and non-obvious type mechanism. But we have to do it differently. And we then work with you to figure out if that's something that can be protected. And then also work with the inventor to say, hey, maybe this can't be protected, but this is going to be the best way to develop the product. What do you think? And is there anything else we can add to it that can be protected?
Vincent, can you explain why a patent search should happen before product development and what can go wrong if you happen to skip that step?
Yeah, I mean, that's a great question. I mean, when we do the patent search, we're looking to see if we can get a patent first and foremost, right? And I always say it's like searching for the needle in the haystack. When you find the needle, you're done, right? But the problem is, a lot of times you can't find the needle. It might still be in there, and you're looking and looking and looking for things that are very similar. And so when we see when a lot of products that are very close to it, we can help guys like Andrew say, look, we got to stay away from this, and we have to stay away from this because those are patentable um, parts of it. So it certainly helps as far as that goes. And like I said, it stops the bleeding. If we find it, we just stay away from it, and we try to design around it. So the search helps me to draft the patent because I know what's out there and I try to draft around it. It helps the the manufacturer so they know what they can do and what they can't do. And if you're looking for financing, venture capitalists or angel investors, they're going to want to know, did you do a patent search from a reputable attorney with a well-reasoned argument that you can get a patent? Have you filed for the patent? Have you got the patent? Have you done the prototype? Those are all the questions, but it always starts with the search.
And Andrew, like let's say you finalize the design. Can you talk about why a provisional patent is such a valuable tool before you go to market?
Yeah, definitely. So you get that year of, again, like Vincent said, it's a race to whoever. It used to be whoever invented first. So if you could, and I'm not a patent attorney, so if I say some of this stuff, and Vincent, correct me if I'm wrong, but it used to be that it was whoever invented first. So if you came up with an idea, you wrote it down, you put a date on it, and signed it, that I think was, if you could then prove that you came up with that before somebody else got a patent, then you would
Yeah,
have the
they used
priority
to call
date.
that the poor man's patent. You put
Yeah,
it, you describe it, put an envelope, and you mail it to yourself, and then you don't open it. It's got the post date to prove the date of it. Yeah. So that,
Does
yeah,
that work? Did that work? Did that work back in the day?
yeah, because like he said, it used to be the first to invent. If you can prove you invented it first. But in 2013, Obama signed the American Invents Act, and we joined the rest of the world and said first to file. So it's the first inventor to file. So it changed from the first inventor to invent it to the first inventor to file the application. Sorry to
yeah,
cut you off there, Andrew. Go
exactly.
ahead.
And
Yeah.
and I have a bunch of pages from when I was a kid that I signed and dated. I never mailed anything to myself, but I definitely signed and dated some stuff. I don't know how valuable it is, but so yeah, so it's first to file. So the provisional patent is a really cool tool to be able to quickly and very cost effectively get that priority date. You still have to, the caveat to that is you still have to file. Like if you just let the provisional patent run out, then nothing happens. You don't get that date. If somebody else can file then and file
Yeah, it
you.
becomes abandoned. Yeah,
Right.
that's like a misnomer. A lot of people call it a provisional patent, but it's really a provisional patent application. A provisional patent application never becomes a patent because you have to file a non-provisional within that first year. 364 days later before midnight, you have to file the non-provisional. And then when you file your non-provisional, the search begins from the date that you filed the provisional a year before. So anything that happened in the meantime, so if you went out and you showed it to somebody and they raced to the patent office and filed an application, you would have won the race because the examiner won't even look at anything after the date that you filed it. It's all before the date you filed it.
Exactly. And then you can use that year, up to a year. Definitely don't want to be racing till the 364th day at midnight
Yeah,
trying to file anything. That makes it hard for you, Vincent. But
exactly.
sometime within that year, you have that whole year to you want to do as much as you can to prove to get as far as you can with the product. So whether you use that for design, engineering, prototyping, production, manufacturing, marketing, sales, it's a lot to fit into a year. But and
Yeah, I
that's
always say it's 10 months. You got to tell me within 10 months. I jokingly say my price doubles if you call me 2 weeks before the deadline.
yeah.
And I've never doubled. I never charged anybody double, but I threaten to so they don't. give it to me at the very last minute. I
Yeah.
got a couple clients calling me this week, saying, could you do something, before July 5th or something? And it's, it definitely puts the pressure on us. But yeah, I mean, like you said, the year flies by. You don't really have the year. You have to see that it's going somewhere. Andrew, when do you say, look, this isn't going anywhere. You're not going to make any money. There's a tipping point. Let's, stop throwing good money after bad and let's just give this up. I mean, when do you feel like you have some positive momentum and this thing is going? I mean, I filed provisionals before and I've had clients call me the week later. I just signed this big contract with this big company. We need to file the non-provisional right away. And then
Yeah.
I have clients 10 months later saying, oh, I really haven't done anything in the last 10 months. And now I feel like I just want to, lose everything I got going into it. So let's file it. And I'm like, I'm glad I want to make money. You want to hire me to do it. But at the end of the day, I want the inventor to make money. So when do you're just one part of it. And I was talking earlier, you have to be able to manufacture, market and distribute. And all those three things, really, you're just in the manufacture end of it, right? You don't do the distribution or the marketing part of it.
We do from end to end actually. So
Okay.
from idea through design, engineering, prototyping, manufacturing. And for manufacturing, we coordinate with other manufacturers all over the world, and then we also do marketing. So the marketing is a relatively new service that we've offered, but we've seen from the last many years since we started what works and what doesn't, just by working on some of these projects. And the reason that we started offering that service is because we've done it ourselves for our own projects. We run all the marketing for for Stoke itself, although service businesses are different than product, but we know how that all works. And so, and people were coming to us like, hey, we love our product. Thank you for developing it, prototyping it. We're all ready to go, but how do we prove demand? How do we market it? And maybe they're not ready to manufacture it yet, but they got stuck. So we decided to also help with the marketing so that we want to be involved in the whole process and the whole success story, or as much of it as possible, and we can have some control with the client on how that plays out if we can help with marketing as well. And so and we understand the product really, really well because we developed it, so we understand all the benefits when it comes time to building an e-commerce optimized website and making ad creatives and doing all that stuff. We know it really well, so we don't have to discover and learn the product all over again. And so what we can do though is, to answer your question, is before we have to do some kind of development. We have to have a prototype, something that we can put our hands on, test. We have to have that at the very least. Now, from there, we can once we've iterated made any design changes as necessary, we can make a professional looking prototype that looks pretty similar to a production unit. We're doing that with a few products right now, actually, where we can use that for videos, for pictures. You wouldn't really be able to tell the difference between that and a final product. And we can either help run a Kickstarter or some kind of crowdfunding campaign, like with Kickstarter, Indiegogo, or we can do that on, we build a website and we do that on the website itself. So we get pre-sale or pre-launch revenue before the product is manufactured. That indicates demand that, and we can tell there if we're putting a good amount of money in for several months, for 3 to 6 months, and we're just not getting the return that we expected, then maybe that's time to pull the plug. But at least we're pulling the plug before the client has spent a bunch of money on tooling, which is typically when you're making a physical product, the tooling for manufacturing, which are for plastic components, is what you inject the plastic into, and they're big metal tools, and that tooling is actually typically one of your biggest expenses throughout this whole process. So we can figure out whether or not the product has has potential before the client has to pay for that, has builds up a room full of inventory, goes through all that. So that's the kind of the cheapest, fastest way to get there. But you still have to develop and prototype. Like, you can't shortcut that part. You got to go through the search, the patent search, and possibly a patent, and definitely at least a provisional application. So when you launch it, even as a pre-launch campaign, you're protected in some way there.
Excellent. Excellent. Thank you so much for the information, gentlemen. I appreciate the time.
Hey, thanks, Andrew. I really appreciate coming on. I think this will be valuable information for inventors.
Absolutely. Thank you so much for having me, Vincent, and great talking with you, Evan. This has been really, a really cool experience, and hopefully people find it useful.
Pleasure's all mine. And thank you all for joining us on Guardians of Innovation. If there's one takeaway today, it's this: patents are powerful, but only when they protect the right version of your product. To learn more about intellectual property protection, visit LoTempioLaw.com. And to explore product development and early stage launch support, check out StokeVentures.com. Don't forget to like, subscribe, and leave a review if you love this information.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.